So after this 2-week term, you're pretty much in good shape for MFSA to give you the in-principle approval. And again, the MFSA would then go through the revisions and start working. They might call you to ask for some comments or some revisions or send you some emails. So there might be some exchanges at that level. But eventually, the MFSA will issue an in-principle approval under Step 10. And it's at this stage that we would typically incorporate the CCAV. The CCAV can also be incorporated before, if the client is keen to actually finalize the formalities like having the launch board meeting. But this is the more common step plan that we typically implement. So at this stage we incorporate the CCAV and we set the date for the launch board meeting of the CCAV. The launch board meeting is probably one of the most important meetings because during this meeting the board approves the structure and all the contracts and prospectus and KID and supplements that we would have worked on for the previous weeks. And ultimately, after the board meeting, we would have a batch of documents all approved by the board, ready for execution. And it's at this stage that we make a final filing with the regulator after we would have agreed the date for the license. We would typically give the regulator like a week time from the date we file the documentation until the date we get the license. And at this stage, we make a final submission, and then during that 1 week, we follow up with the various service providers on the execution of the agreements and the letters of engagement. And at this stage, we would have, towards the end of this week, we would have a final pack of signed contracts and final dated prospectus offering supplements and the rest. And that's where, hopefully, by the end of that week, we would get the license, and then we would proceed with the launch of the fund and the opening of the initial offering period. So this is, in summary, how it works. It takes, on average, between 10 to 12 weeks, realistically. And you need to factor in, if the structure is not very straightforward or it's quite complicated, you should add a couple of weeks to that. But MFSA generally stick to the 12-week term. We now move on to the setting up of a fund management company. In the case of a fund manager, the structure is typically slightly more complicated because you also go into issues of employment and stuff like that, which I'm not going to cover here. But in terms of process, it's slightly more complicated because you have all these peripheral points. In terms of structure, you have your fund management company here. I'm not going to go into shareholding structures because ultimately it varies depending on the particular needs of the client, especially if they're offshore, if they're not Maltese clients. You have the fund management company. You would typically have, so you have a board of typically 3 members, an investment committee. Now again, the investment committee must be made up of at least 3 individuals, and they must have a verifiable investment management background. When I say verifiable, I mean that you need to be able to show to the MFSA qualifications or relevant previous experience, or provide to the regulator reference letters from regulated entities confirming the competence of the proposed members of the investment committee. The investment committee's role is to oversee the activities of the portfolio managers, to set the strategy of the fund, to issue rules on stock selection, and to set the high-level asset allocation, with the portfolio managers, who would typically be employees of the fund management company, responsible for assuming responsibility for the day-to-day investment management process. This structure assumes no outsourcing. So the structure assumes that all the investment management and risk management is undertaken in-house within the fund management company. We'll see in the next slide the requirements in terms of where we have a situation where the investment management is outsourced. So in this case, we have an investment committee of 3. They have to meet at least on a quarterly basis, and you need to have at least 1 Maltese resident member on the committee. In terms of portfolio managers, the MFSA would typically insist for at least 2 portfolio managers if the client is a UCITS. So if we are setting up a fund management company for a UCITS client or a retail structure, in view of dual control considerations, MFSA would insist for there to be 2 portfolio managers, as a minimum. If we're setting up a management company for a PIF, subject to having in place the necessary business continuity arrangements, we could start off the structure with one portfolio manager. But we need to have an independent investment management function, which is vested in the investment committee and the portfolio managers, and an independent risk management function. That means a full-time risk manager employed by the fund management company. So in order to have a structure which works without outsourcing, as a minimum, you can have one portfolio manager as an employee and one risk manager as an employee, as a minimum. If you're servicing UCITS, you need at least 2 portfolio managers as employees and 1 risk manager independently monitoring from a risk management perspective what the portfolio managers are doing. Then you need to have the compliance function, which can be outsourced to a company like Adams, for instance, and you need an MLRO. The MLRO would typically be either one of the portfolio managers or one of the members of the board. It really depends. Within the context of a fund management company, the AML obligations are not that onerous for the simple reason that the client is a fund and you have an administrator doing all the AML checks on the investors. And you would typically rely on the checks undertaken by that administrator. So within the context of a fund management company, as we said, of this type, you would typically structure it with 2 full-time employees if it's a hedge fund type operation, 1 undertaking portfolio management and 1 undertaking risk management. The investment committee members and the board would obviously not qualify as employees for the purposes of this assessment. A compliance function would also need to be put in place. So that is typically a very basic structure for a fund management operation. If there is a level of outsourcing, in terms of local presence and staffing requirements, you would typically have slightly less, in the sense that you would always need an independent risk management function. I'm assuming here that the sub-investment manager would typically be, say, a UK or a fund management company based and regulated in a reputable jurisdiction, right? So you need to assume that. The investment committee would also assume a monitoring over the investment management function, so over what the sub-investment manager is doing. Essentially, we are replacing the portfolio managers with a regulated sub-investment manager. But here MFSA would insist that the investment committee would probably need to meet more often and assume a more active role in terms of overseeing the activities of the sub-investment manager. And we would typically fulfill this by identifying 2 of the 3 members of the committee that would take an active role in reviewing and receiving reports from the sub-investment manager in terms of the management of the assets of the fund clients of this company. We would typically then always need a compliance function and an MLRO. That's very standard. So in this case, the main differences here are that we have a regulated sub-investment manager, which is replacing the portfolio managers that we had before here. And we, MFSA, would typically expect the investment committee to take a much more active role in overseeing the delegate. Because again, let's not forget that Maltese license holders, which outsource certain function, must and are required to carry out an oversight function over the activities of their delegates. So that is a key rule in the rule book of the MFSA that you need to keep in mind, and this is why the committee would need to take a more active role in terms of overseeing the sub-investment manager. Licensing process. The licensing process, the SEPLAN, is pretty much similar to the one for the funds in terms of identifying the optimal structure for the client. Certain clients which are, say, going to manage UCITS would go for a UCITS management company like Anthony's company, for instance. Other clients, other managers would typically, if their intention is not to manage UCITS but rather to manage alternative investment funds, they would then go for an AIFMD type of authorization. So identifying whether to go under UCITS or under the AIFMD is an important decision, because ultimately when it comes to passporting and marketing, it makes a big difference. So it's important that you keep in mind that another consideration is that you can have an entity which is both a UCITS management company and an AIFM, because under the AIFMD, it caters for dual authorization, okay, being both a UCITS 4 and an AIFMD firm. So that is also possible. Once we've structured it and we've drawn these diagrams and we've put names instead of, for the purpose of the investment committee and the board and with the shareholders and stuff like that, and we've identified who will be fulfilling the risk management function and so on, at that stage, we would then start preparing the documentation. And here, you need to prepare an application form, a very detailed business plan, financial projections for the first 3 years, including P&L, balance sheet, cash flow statements, and stuff like that. Financial resources statements, terms of reference, which will regulate the proceedings of the investment committee, detailed procedures for the portfolio managers, the risk management policy, if it's a UCITS, but under the IFMD, we will also need to see most likely a risk management policy at application stage, the M&A of the applicant, corporate resolutions, and very important, the review of the due diligence documentation on the various parties involved.